Welcome to Jackson Lewis's podcast, We Get Work. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every organization's mind: how will my business be impacted? Class action lawsuits in response to data breaches have skyrocketed as plaintiffs look to take advantage of courts' perceived leniency regarding standing. On this episode of We Get Privacy for Work, we discuss what employers can do to shore up their legal defenses in the event of a data breach. Today's hosts are Damon Silver, co-leader of the firm's privacy, data, and cybersecurity group, and Jonathan Harris, principals, respectively, in the firm's New York City and Nashville offices. Damon and John, the question on everyone's mind today is, what accounts for the recent rise in data breach class action litigation? What can employers do to minimize risk? And how does that impact my organization?
Welcome to the We Get Privacy podcast. I'm Damon Silver, co-leader of the privacy, data, and cybersecurity group at Jackson Lewis. In that role, I receive a variety of questions every day from our clients, all of which boil down to the core question of how do we handle our data safely? In other words, how do we leverage all the great things data can do for our organizations without running headfirst into a wall of legal risks? And how can we manage that risk without unnecessarily hindering our business operations? On each episode of the podcast, we talk through a common question that we're getting from our clients. And we talk through it in the same way that we would with our clients, meaning with a focus on the practical. What are the legal risks? What options are available to manage those risks? And what should we be mindful of from an execution perspective? My usual co-host, Joe Lazzarati, is out today, but we've brought on a special guest, John Harris from our Nashville office. John's a key member of our practice group and the driving force behind a lot of the great results we've been getting in data breach class actions. So John, our question for today is what's going on with all these data breach class actions? And just to set the stage, I'm going to share some year-over-year statistics. In 2021, about 300 data breach class actions were filed. In 2022, that jumped to 600. That number more than doubled to 1,300 in 2023. And last year, we were up to 1,500. So John, what is your take on why so many of these cases are being filed?
Well, first of all, Damon, pleasure to be here. And to answer your question, I have two answers. First, my friends on the plaintiffs bar have realized there's gold in them hills. More and more plaintiffs firms are racing to get into this space because they see it as lucrative. And the number of players is starting to grow and grow and grow. Secondly, breaches, they're not slowing down. They're picking up, if anything, and there's more and more opportunity for plaintiffs to file lawsuits over this. Another trend I'm seeing, too, is that you'd see lawsuits attacking the large breaches, 100,000, a million, et cetera. We're seeing more and more now as folks try to get into the game, they're taking a stab at the smaller breaches, 1,000, 5,000, et cetera. And so we're seeing more and more of those pretty modestly sized class actions as well.
Yeah, and John, just for some of our listeners who may not have had the pleasure of being on the defense side of one of these claims, what do they typically look like? What are the plaintiffs alleging?
Well, the usual smorgasbord of claims you'll get, first and foremost, it'll be a negligence type theory that, look, you the hospital or employer, you're the ones maintaining the server. You didn't keep it safe. You owed us a duty to keep it safe. You're negligent. They'll also typically add on implied contract claims, unjust enrichment, common law claims like that. If you are fortunate or unfortunate enough to be in California, as the case may be, California also has some statutory provisions they will always sue under as well.
Yeah, and so John, how does this typically come about? I mean, obviously, it's a data breach class action, so the party being sued had a data breach. Is it after the notices go out that we're typically seeing these filed? Can you take us through, where the client typically is from the standpoint of managing the data breach? And then what do the initial stages look like from a litigation perspective?
Yeah, sure thing, David. So what typically will happen is the client will have a breach. They learn of the breach. They immediately call their data privacy experts and will engage in incident response, where forensics folks come in and immediately try to figure out what happened and how do we stop it. Uh, Another side of our incident response team will start working on required reports we have to make to OCR and various state attorney generals. Eventually, under the law, the client has to give notice to all people they know to be potentially impacted by the breach. Usually within a week or two of those notices going out, you'll get a lawsuit. And then if it's a large breach, you usually have 3 lawsuits, 5 lawsuits, 10 lawsuits. It'll be like clowns coming out of a car after notice goes out, where all the usual suspect plaintiffs firms are racing to be first in line in the courthouse. Because you think of that scene from Godfather 2 where they're down in Cuba and they cut up the cake. If you get to the courthouse first, your slice of the cake is bigger. And so you're racing to get there as soon as possible.
Got it. And are you typically seeing these cases brought in state court, federal court, a mixture?
It's a mixture, more state than federal, honestly. Sometimes the plaintiffs will file in federal court if the case is big, because they just know that under the Class Action Fairness Act, if it's big enough, I'm going to remove it there. Often they will file in state court, however, try to keep us in a form they view as more friendly.
And are you seeing these concentrated in particular jurisdictions, or are they being filed all over the place?
They're all over the place. So we have coast to coast. We got matters right now we're handling in all 4 time zones, and they're everywhere.
Got it. And so say we're dealing with one of the larger incidents, there's 7 lawsuits filed, there's 10 lawsuits filed. Are we generally able to consolidate those? Is that something we're getting pushback on?
95% of the time, those will all get consolidated into one matter. The 5 to 10% of the time, sometimes that clown coming out of the car that was 10th rather than first, they will try to file in a different forum so that they can circumvent the first 9 clowns that got to the courthouse in time. That can actually present some opportunities to the defendant, because you can try to play those 2 camps off each other when you're trying to settle the case.
Got it. And I know we had a matter like that somewhat recently. I believe it was in Alabama and Tennessee, and obviously we won't go into client identifying information, but how did that one end up playing out?
The one I'm thinking of actually was up in Pennsylvania, and a client, big breach, got sued for 6 or 7 lawsuits, all in federal court. And the 8th person in line, rather than suing in federal court, sued in small town country Pennsylvania court. And rather serving a client via CT Corp or their registered agent, they just dropped by the hospital and dropped off the packet, and that was that. And whoever at the hospital got it didn't think it was anything. And so, lo and behold, 30 days comes and goes. Client doesn't know about it, and they can't remove that case. They're stuck in state court there. We actually settled with that last person in line rather than the first 7, because that law firm was willing to cut my client a deal to box out the others.
Got it. And what about arbitration? Are we seeing these being brought as arbitrations as well, or is it almost all in court?
Almost all in court. The point about arbitration that is important, say you're a hotel chain, and when you click on the hotel link that you're getting a room, you've probably signed an arbitration agreement without knowing it. That can actually be really helpful in defeating class certification. There's some good case law out there that says, look, if some folks have arbitration agreements, some don't, that's such an individualized issue that we really can't have a class.
So let's say one of these cases comes in, John, and we're going to handle the case. We're reading through the complaint. Maybe we've had some initial discussions with the client, and we're doing our initial case assessment. We're trying to get a handle on what type of exposure the client has. We're trying to formulate our defense strategy. What are some of the factors that you focus on?
Great question, Damon. There's some basics. You talk about, all right, how many folks we talking about who are impacted? Is it 1,000 or 1,000,000? This is a numbers game at some level, and so the size of the class is really important. what types of data were exposed and how many of the class had that data exposed. It's really often that in a class of 100,000 or a million, you might have some, but not all, who had social security numbers impacted. And at mediation, if 20% of the class had socials impacted, that's something you can point towards as far as a lower valuation on the case. To defend any negligence type claim, we'll also look at what was the client doing before all this happened. Did they have they talked to my friends in our data privacy team about what policies and practices they need to have in place? Were they doing periodic reviews of their systems for security threat analysis, security risk analysis, to see how vulnerable or not vulnerable were they? From time to time, do they engage an expert to pretend to be a threat actor and see if they could poke holes in the system? Do they discipline people who violate our data privacy policies? Do they train their employees on that? Often these breaches will come because an employee clicked on a phishing scam, and there's only so much training one can do to prevent an employee from doing that. But you got to show that, look, we were trying to do that, every so often. So I'm looking for, all right, what steps did the client take proactively ahead of time to protect themselves and their data?
Yeah, I think that, and I want to just double click on it, John. I think that's a hugely important point. Like, what was the state of the client's program at the time of the breach? And that can have, multiple impacts. One of which is, let's say, for example, the client was pretty disciplined about having all of their data stored within an EMR or another application that had encryption at rest. That might give us an argument that even though this data was exfiltrated, it would have been completely useless to the bad actor, which obviously is going to have impact on the potential for harm to the class. And also, if we assume that this is a situation where the client had a pretty solid program, they've been doing risk assessments, they had a written information security program, they're going to have a lot less to fear from discovery, which will allow them to, if they otherwise feel okay about the case, take more aggressive positions. If you're terrified about what depositions are going to turn up, if you're terrified about having your executive team depose because they're going to have to fess up to the fact that you cut corners and didn't want to put industry standard safeguards in place, that's going to influence how you can handle the case. You're really going to have to know that some way, somehow, you're going to have to resolve it before discovery, because otherwise that could blow the lid off of things. So I do think that that's an important point in having discussions with clients around compliance. Is it's not just a matter of checking the box. It really is going to have downstream impact if you are unfortunate enough to end up in one of these litigations.
No doubt about that. The key to defensibility in these things is what you did in the weeks and months and years prior to the breach.
Yeah, 100%. So to talk a little bit about what the early stages of the case look like. So are we typically moving to dismiss?
More often than not, we will file a motion to dismiss, usually on standing, because people are racing to get to the courthouse so quickly. They often have little to no concrete harm that they have pled. And if there's no injury in fact, then you don't have standing to sue. And so most defendants, not just us, but most firms out there, will usually file a motion to dismiss. The trend lately has been for more and more of those motions to get denied, even when there's no there in what the plaintiffs are alleging harm-wise. It's been becoming an increasingly uphill battle to win a motion dismissed based upon standing.
So just to flesh out the standing point a little further, John. So is it not sufficient to establish standing that I received a notice that my data was impacted?
One would think that if Article 3 standing actually meant something, you would also have to plead, not only was my data impacted, but the threat actor has taken out a credit card in my name, or they fraudulently charged something to my credit card, or they took out a loan in my name, or they did something that's caused me actual concrete harm that I can articulate. But courts aren't really requiring that anymore. If your data was stolen or viewed, and if you got a few spam phone calls, or had a threat actor claim to put some stuff on the dark web, then courts are more often than not letting the case go forward.
Yeah, and that's an interesting and from our standpoint, unfortunate development, and I think it does, or it should, in any event, impact how companies are thinking about the incident response piece, and in particular about what their notification strategy should be. Because there are instances where it's hard through the investigation, or expensive through the investigation, to identify every person who is actually impacted. And so there can sometimes be this question from clients of, well, why don't we just send notices to everyone? And that way we don't have to do as extensive forensics. We don't have to do data mining. And the downside to that approach, which does have some merit, is exactly what we're talking about here, which is that maybe if you had done all that analysis, 100,000 people would be impacted. But here you're sending out blanket notice to 500,000 people. And if getting that notice is going to be enough to get you past a motion to dismiss, you're now looking at a pretty expensive lawsuit, even if it turns out that only 20% of those 500,000 people actually were impacted by your incident.
No doubt about that. And in your 100,000 versus 500,000 example, to the plaintiff's bar, this is just a numbers game. They see how many notices went out, and they can usually see that on a number of attorney general websites that we have to report to. And so they see 100,000 and they do, all right, that's 100,000 times 10. Or they see 500,000, that's 500,000 times 10. That's what they're thinking. And if you send out 5 times as many notices as you have to, on my side, that on the litigation side, then the price of poker has gone up by 5 times.
Yeah, absolutely. It's definitely something that, in the early stages when you're making those decisions around notice, you do have to be mindful of, because it does have that downstream impact. What about class certification? Is challenging class certification something that is common? Is it something that you look to do?
Great question. And because so many of these cases settle relatively early, the number of decisions where a court, after discovery has happened and gotten to class certification and made a ruling on it, they're pretty few and far between. There's been a very recent case out of the Middle District of Florida in late June, and a lawn running saga with a restaurant chain you would recognize, where a judge denied class certification. And the court's reasoning, what I thought was pretty reasonable. It was, well, look, every single plaintiff and class member is going to have an entirely different story on causation. If you've been impacted by one breach, maybe you can trace this breach to your harm. If you've been impacted by 30 breaches like Ticketmaster and all these other companies that have been high profile, how are you going to pin your harm on me? And that's going to be a person by person by person inquiry that makes class certification wholly unsuitable. So there are not a lot of decisions out there on class certification in this space. We've had 2 recently break our way, and that's a pretty helpful talking point for us to have in mediation.
Yeah. So how are we typically determining whether certain of the plaintiffs had information impacted in prior breaches? Are there steps we're taking to do that? Are we relying on discovery or pre-mediation information exchange? How does that play out?
Great question. First, whenever I get a new lawsuit in, right out of the gate, there's a website where you can actually, if the client has the plaintiff's email, I can search to see how many times that email address or their phone number has been impacted by a past breach. Often that will provide you some goodies that you can use right out of the gate. In discovery, one of my main goals in discovery when we send written discovery to the plaintiff is, all right, I need to know every breach you've been a part of in the last 5 years, 10 years, et cetera. And then I'll often, the number of high profile breaches are easily findable. There are plenty of websites that track them. I'll often ask them, all right, hey, are you, do you use Ticketmaster? If so, you might have been impacted by that breach. And so I'll flat out ask about 10 or 20 recent high profile breaches, see if they're a customer. That gives us an argument on causation too, that maybe that breach, not this one, caused their damage.
Got it. And sticking with discovery, and maybe this is a good last question for us. What are the plaintiffs typically looking for from us? And what do we typically agree to provide?
Well, they're usually looking for the kitchen sink, which I don't agree to provide. They often want to drill down into pretty in-depth a lot of the questions we were talking about earlier, as far as what steps had the client taken earlier to prevent breaches, what training have they done, what's the forensic explanation for how exactly the breach happened, do we even know how it happened, was the whole patched, does the client engage or require multi-factor authentication to get onto the system. And so they're really delving into the build up their story on negligence. Were we doing everything we could to prevent a breach?
Yeah, and again, I mean, not to beat a dead horse on this, but this does highlight the importance of having a good data security program because, of course, especially if it's just in advance of mediation, we can stonewall, we can say, we're not providing our WISP or our risk assessment, other information about our program, but it's not too hard for plaintiffs firms to read between the lines on that. And if by contrast, we feel really good and we want to, lead with, a position of strength, showing that we had this really solid program in place and negligence is going to be hard to prove, that is going to give us a lot more leverage in the negotiations. And again, it's going to give us more confidence to litigate the case the way that we ideally would like to, because we don't have to be as fearful about what's going to come out in discovery.
No doubt about that. And discovery responses, I would love to be able to articulate in great depth about all the great security practices we had and how this was a one-off because someone clicked on an email. But we have to have those arrows in our quiver to be able to play that card.
Yep, exactly. Well, John, thank you so much for making the time to come on the pod. I mean, this is a very fast evolving area. It's one that we get tons of questions about. And so if you're open to it, I think there'll be lots of opportunities to have you back on. For everyone listening, thanks for taking the time to join us. As always, if you have questions or comments about this episode or suggestions for future episodes, you can email us at privacy@jacksonlewis.com. Thanks, everyone, for joining. And thanks again, John.
Thank you, Damon.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com.